So here we go with part 2 of chapter 5, where we will basically be discussing the Bill of Rights. So Bill of Rights effectively refers to the first 10 amendments to the Constitution, and these substantially affect government regulation of business. Obviously that's not all they do, but since this is a business law class, important to note that. Basically prohibit federal infringement on individual freedoms. And then if you look to the 14th Amendment, that applies or extends the Bill of Rights to states. So state governments are at that point were also not allowed to infringe on the rights listed out in the Bill of Rights. In addition, like artificial persons or people like corporations that kind of have their own substantive entity where they are considered by, in many cases in the court systems, I don't want to say a person, but they're basically treated like a person in many cases. So some, but not all of the times, the Bill of Rights may be extended to corporations as well. Now, as we go through the 1st through 10th Amendments, these are just brief lists of what is included in these amendments. Your book talks a little bit more in depth about them, so I'll leave you to that reference most of the time. I'll maybe say a few words in addition to just these basic outlines. So most people have heard of the First Amendment and know that freedom of speech falls within that amendment. Freedom of religion as well, press and peaceable assembly. Freedom of speech and religion have been issues that have come into the workplace and been the subject matter for some pretty high-profile court cases. There's one a few years ago again where Hobby Lobby was one of the, I guess they were the plaintiff. Actually, I don't even remember. Basically, Hobby Lobby was a party to a case where there was a law that basically said they had to provide contraceptives for their employees as part of their health care, and they claimed that that violated their freedom of religion because it went against their morals to encourage birth control in that way. Something that some people don't know is in the First Amendment is that it is what ensures that citizens have the right to ask the government to redress grievances. Of course, that doesn't always mean they will, but you can always ask. Second Amendment, most people know as the right to bear arms. Yeah, I mean, if you read the first part of that, it may not explicitly state the right to own private weapons in the way that most people feel that it has evolved to this point in this day, just because they have that well-regulated militia in there, and obviously a militia is kind of a outdated system of protection for the most part, unless you consider the National Guard a militia. But definitely for security. So if you kind of separate the militia from the security component, I think that's where most interpretation has gone. Third and Fourth Amendments. Third Amendment means the government cannot house soldiers in private residences during peacetime or during war except for provisions in the law. And quartering of troops in private residences is not something that's happened in a long time. Mainly because of this. Well, I don't know about mainly, but we haven't exactly fought a lot of wars on our own soil recently. But this kind of stemmed from the Revolutionary War and others from that time period where this was a common practice. Not super applicable to the business world. Fourth Amendment protects citizens from unreasonable search and seizure and ensures that government issues warrants only with probable cause. Now, determining what probable cause is kind of a sticky situation. which we won't get into too much, but I think there's a couple cases in this chapter, excerpts that get into at least the unreasonable search and seizure aspect of that. The Fifth Amendment, most people know from the phrase, "I plead the Fifth," basically saying that you can't, or you cannot be forced to testify against yourself in a way that would incriminate you. Double jeopardy is another important component of it, where you know if the government tries you in a case, in a criminal case, and they lose, they can't come back and try that same case over again. This is also what creates the right to due process, so that life and property, etc., cannot be taken without due process of the law. And also kind of a check on the eminent domain, where government cannot take private property for public use without just compensation. Now, something that, again, is kind of a sketchy term there is just, because obviously that's pretty subjective test, and many people who've had their land or homes taken through eminent domain would claim that they did not receive what they would consider just compensation. Anyway, Sixth Amendment, right to a speedy trial with an impartial jury, right to know any criminal accusations a citizen might face, right to have witnesses both for and against the accused, and this is what grants the right to an attorney, and where the public defender system kind of a necessity arose. Seventh and Eighth Amendments, you got the right to a jury trial. Obviously that $20 figure is quite outdated, as you know, who in their right mind would try to go to any type of trial when there's less than $20 in monetary value that's at stake, considering the high price of adjudicating a case. Eighth Amendment, excessive bail is prohibited. Again, that's pretty subjective based on the judge setting bail. Excessive fines, again, the word excessive, pretty subjective. Cruel and unusual punishment, that's one that at least has made it through the court system quite a bit, so that's been hashed out a lot, but that's where that comes. Ninth and Tenth Amendments. Ninth Amendment is kind of a catch-all that says, even though, I mean, this is basically saying this is not an exhaustive list of rights, so if there is a right that citizens have at large, just because it's not listed in the 10 Amendments or the Bill of Rights does not mean it doesn't exist. 10th Amendment, any powers that the U.S. Constitution does not explicitly give to the federal government are reserved to the states. So this one gets a little sticky because, if you look at the history of like the Commerce Clause, which I was just talking about a little while ago, there are situations where a little bit of power granted by the Constitution has been the source for opening up a much larger amount of power through that, tiny crack, I should say. So depending on how the courts rule, oftentimes just a very small grant in the Constitution that is later expanded through case law or whatever the case may be, is often still considered constitutional because of that little kind of seed of power that was planted in the Constitution. Also makes it kind of interesting that the federal law is the supreme law of the land, but the 10th Amendment is kind of suggestive that the states should have kind of more power than the federal government does, at least in the scope of what they have power over. So it's just kind of an interesting juxtaposition there. 14th Amendment, prevents states from denying equal protection of laws to any citizen, combats discrimination since it applies whenever government treats certain individuals differently than other similarly situated individuals. And we also talked about how this is the one that applies the protections of the Bill of Rights to the state level as well. Now, when a court is testing for violations of the 14th Amendment, they use different tests depending on the situation. So going in order from the easiest to, or the hardest to pass down to the easiest to pass, strict scrutiny applies to any suspect classifications based on race, national origin, and or citizenship that would prevent individuals from exercising a fundamental right. Such classification allowed only if necessary to promote a compelling state interest. So, if there is something that a law made that has different classifications or effects based on race, national origin, and or citizenship, the test is, does that law or classification, is it necessary to promote a compelling state interest? And obviously, necessary and compelling leave room for a lot of judicial interpretation, and then many cases have gone through the court system that are kind of hashing out what necessary and compelling actually mean. But suffice it to say that for something to have to be necessary and compelling is a pretty high bar to pass. So a lot of the adjudication, a lot of the common law, case law that comes out of items that are undergoing the strict scrutiny test end up being disallowed. Intermediate scrutiny applies to classifications based on gender or on the legitimacy of children, and these are only allowed if it is substantially related to an important government objective. So you see the difference in wording there, necessary versus substantially related, and compelling state interest versus important government objective. Well, where do those two overlap, or where's the boundary between those two? Often difficult to tell. Again, there's been much case law that has gone into kind of hashing that out. Then the rational basis test pretty much applies to all other matters. So anytime any of these categories are not involved, then the classification is allowed if it advances a legitimate government interest. Again, you still have that word legitimate that's subjective. So the rule itself is not kind of super self-applicable. It's hard to, without reading all of the cases that have gone to kind of hash out what that means, it's tough to interpret what that means just from reading what you have here. All right, now I got a couple more hypothetical cases that we'll take a look at. Hypothetical case 3. The annual Smallville Fair is the community event of the year. Attendance is always high, with community members enjoying the thrill rides, exhibits, and food. Lori Cuthbert, Smallville High School's principal, is there, and as she turns the corner by the Ferris wheel, she is shocked by what she sees. The school's star quarterback, senior Coy Gunner, is wearing a green t-shirt depicting a Christ-like figure smoking a marijuana joint in large yellow letters. On the front of the shirt are the words, "Joints for Jesus." The back of the shirt reads, "WWJS, what would Jesus smoke?" Cuthbert immediately confronts Gunner, exclaiming, "Coy Gunner, I cannot believe you would wear such a disgusting shirt. You have offended my Christian principles and beliefs, as well as the religious beliefs of the countless numbers of Smallville citizens attending this fair. Further, you have disgraced the high school. As the star quarterback of our football team, you of all people should know that you are a role model for your fellow students. as well as younger kids in the community. I will see you in my office on Monday morning at 7:30 a.m. On Monday, Gunner arrives at Cuthbert's office to discover that she's decided to suspend him for 10 school days. Gunner objects, saying, "I remember in civics class that Mr. Campbell told us that we have the right to free speech. I object to the suspension, and if you don't change your mind, my dad knows a good attorney who might want to speak with you." Question, again for thought or jotting down for future discussion. Is the message on Gunner's shirt constitutionally protected free speech? Would rational limitations on free speech justify Cuthbert's decision to suspend Gunner? Does it matter whether the incident occurred on or off school property? Now, some of this is hashed out more in the textbook, where you get a better idea from a similar case that was already decided. But just give that a thought and see. And then on hypothetical case 4, in response to a rising tide of gun violence, the City Council of Stuart, New Jersey decides to ban the sale and possession of assault weapons within its city limits. A coalition of 10 gun stores within the Stuart city limits, in addition to a group of their most loyal patrons, immediately files a lawsuit stating that the City Council's move is a violation of Second Amendment rights. Research whether U.S. cities or states have laws on the books that ban assault rifles. If you find that some do, research whether these laws have been challenged in the courts. If you find some instances, what were the outcomes? Do you believe that the Stuart City Council is violating the Second Amendment rights of its citizens? If so, what parts? If not all of the law, what parts, if not all of the law, is in violation? Now, I'm not necessarily saying you need to go out and research this. Your book talks a little bit. If you read the chapter, the whole chapter, I'm not sure if it's just in the highlighted portions of the Smart Book readings, but if you read the whole chapter, I think there's at least one case that's kind of similar to this. Other than that, just again, your opinion. What do you think? Let's assume some states do, some states don't. Or some cities do, some cities don't. Assuming you don't know the answer to that, some of you may be gun nuts that have all these assault weapons laws from all 50 states memorized. So if that's the case, love to hear your opinion, of course. All right, that's the end of this portion as well.